Definitely have all of that stuff done by then. If you do have it done by then, we will not need to come back because the state will dismiss it as long as you give them proof of your driver's license. So once you get your driver's license, just walk it down or mail or fax it or whatever they accept, and give them a copy of your driver's license, and then you will not need to come back. Okay.
Yep.
All right. So you can come up here and get your notice and you're free to go. And any money that you've paid would be reimbursed.
Okay.
Okay.
No worries. I can hear you.
I do not yet have, Washburn, or I probably did, and they're probably gone, actually, so. I don't know if we're actually gonna have the Washburn case or not.
The CV case, is that off?
Yeah, that's just by affidavit, so we just have to, I don't think anyone is here. Is anyone here for Paul Cordy? Nope. Nobody. I'll just have to message Mary, but she was on her own scheduling call. So they probably called and said, what's going on? Friend, can you hear me?
Yes, Your Honor.
We can.
I apologize for the delay. I've had to deal with an unexpected issue this morning and still not under control, but I will make sure that it is shortly. So I apologize for the delay. I cannot see anybody.
It's not necessary, Your Honor. This is Attorney McLaughlin. I don't need to go in the record. My client has appointments to get her driver's safety plan, but needs some time to complete which is necessary to get her license. So, absent the court's objection, I think opposing counsel does not object to an adjournment for her to accomplish that.
Okay, and when does she think that she's going to be able to have that scheduled and get it completed?
You're promising 60 days. Is that correct, Ms. Storin?
Yeah.
I ask a maximum of 60 days. If the court wishes less, I understand. If we don't have it solved by then, we'll plead out one or the other.
I can do October 1st.
I don't work Thursdays, Judge.
Oh, that's right, you do not. I can do September 28th at 1:15.
I can do September 28th at 1:15 as well, Judge.
In the court, in Washburn County?
Monday is our normal intake days, and I have a sentencing hearing in front of Yackle at 1:30. So as long as Christian can cover bonds and we can be done by 1:30.
Does October 5th at 1:45, would that work better?
That works fine for.
My son has his 1 year wellness visit that day.
My client has a child medical thing that day. I apologize, Judge.
And, okay, Mr. Marco, your mornings are pretty busy on Mondays, correct?
Yes.
Okay.
We do split our status conferences in the afternoon. I have the 2:00 hour. Christian has the 3:00 hour. So if we did something around 3 or 3:05, I should be done with my 2:00 by then on any particular Monday.
Okay, that's usually when I do I have my prelim block there, but I could do it quickly before. So we could do October 5th. Can we just say 3? And if you're running a little late, you're running a little late.
Can you be at 3? One moment.
Oh, that's right, her wellness check.
I don't remember the time. Hold on. Give me 1 second. I'm so sorry.
Or I'm completely open. I had something come off on October 7th.
7 is fine with me, Judge. I prefer the morning. I don't work afternoons. Anytime on the 7th in the morning, Judge.
Would the 9th work for Washburn? Or 9:00 work for Washburn?
Jim, we have Tea Garden set.
Oh, yeah, I'm sorry. I'm blanking. We have a jury trial that day.
Okay.
How about the following week, Your Honor? Where are you on the 5th?
It's 1:15, but it's in Rice Lake.
All right.
So.
Well, the 5th is not good, Judge. I guess I apologize for my client has a child medical appointment. Some other day that month, perhaps, or earlier.
Doesn't really work. Doesn't really work. Well, here's the deal. I can go out as far as October 20th in the morning. But then I'm
That's-
gonna be really frustrated if she hasn't done what she needs to do.
So I'll take the 20th and
I've
she,
got a jury trial on the 20th.
How about the 21st?
in the morning.
21st, I am available.
So am I in
9
the morning.
a.m.
All right. Yes, Judge.
9 a.m., October 21st, and I am telling you very clearly right now, Ms. Storant, that you must have your things completed by that day. I don't want to hear something came up and I do not have money and I could not go through with my assessment, okay?
Yes.
Here's the promise,
you.
Judge. She either has her license on the 21st, which case I believe the state will be moving to dismiss, or she'll plead to the charge, one or the other.
All right, okay.
That's defense counsel's promise to you.
Was it October 21st?
Yes.
We don't have a courtroom available at that
Oh,
time.
we don't have court.
We have
Oh, of
family
course.
court that day.
Oh, wonderful. All right.
Oh, yeah. October 20, no, because it's, well, October 26th on a Monday, I can do afternoon.
I can do that. Can you?
I could do 3 o'clock,
I could
3:05.
do- Again, that's my, prelim block, but I could put you on that date and time if we have court.
3 p.m.?
Yeah, does that work for court?
It does, yes.
All right.
Okay, October 26th, we will schedule you for 3 o'clock. Again, if you're a little late, Mr. Marco, that's whatever, it's fine. And then we'll set it for a plea and sentencing. And it may be off if she's done all that she needs to do, so it can be done by paper.
Yes, if we can get this by stipulation, Judge, we'll submit it early.
That sounds good. Anything else?
No,
This time.
no, Your Honor.
Okay, thank you.
You have my business card?
Yes.
Let me
I
give you
do.
another one.
Okay.
Let's get this, in the words of Larry, the cable guy, let's get her done, okay?
Okay.
Well, and like, just explain to her what meant by paper. If she gets her license back, you get me a copy, we'll file some paperwork, and then we don't have.
Yeah, we don't have to have court if you can get it done, okay?
Okay. Yes.
Thanks, Eric. All right. All
Thank
done.
Thank you.
Get her done.
Yes.
We will go on the record in the matters 26 CF 94, 25 CT 28, 26 CT 34, State of Wisconsin versus Zachary Howard. The state appears through Assistant District Attorney Jose Vila in person. We have Amber Sherwood defends in person with Mr. Howard. We're set today for a status conference on one of his CTs and initial appearances on the other matters. Ms. Sherwood, you are only counsel in the CT matters. Were you aware of the felony case?
I was not, Your Honor.
I will print you, never mind, there's a copy of the criminal complaint that is now being served upon counsel and Mr. Howard. What I can do is I can just give you time to go out and talk about it because it's serious. And he needs to understand the charges and the maximum penalties. And then we will come back and we'll go through and have his initial appearances, okay?
Yes, thank you, Your Honor.
All right, thank you. Momentarily adjourned. Ms. Mose? What are you chewing, Miss Mose?
Ice.
That hurts your teeth. It could chip your teeth. We'll go on the record in the matter 25 CT 45 State of Wisconsin versus Vanessa Mose. The state appears through Assistant District Attorney Jose Vila in person. Miss Mose appears in person, but you missed the last court date, I think.
No.
You did not, or it was the one before that.
Yeah.
Okay, and so you needed to take your permit test and that's all you needed to do, I think?
So I did that. I got my test. I just need to
Passed
get.
it?
Yep, I
Good
just need to get the dollar amount for the driver's license and then the vehicle that,
Free ignition interlock?
Mhm.
So how?
no,
long-
not
Oh,
ignition,
you
like,
don't
but
need that?
you know, that qualifies. You can't have like dash lights on and everything has to work.
Oh, to drive.
Yeah.
Yes.
For
to
the
do-
test.
So when do you think you realistically can do that?
So we were just actually talking about that on the way up. We're trying, one of the other workers is gonna see if I could use one of the work vehicles for the truck.
Tribal vehicle?
Yeah.
That would be
So-
very nice.
Mhm.
And so you'd be able to use that. And then, I don't think it's a lot of money to get your license, but
Mhm.
I don't remember the amount, if it's $70.
Yeah, see, I'm not sure about the amount either.
So how long do you think it's gonna take you to be able to have that money to?
I give it a month.
Okay. I can schedule you for September 28th at 1:15, okay?
Okay.
September 28th, 1:15. That means that you should definitely have all of that stuff done by then. If you do have it done by then, we will not need to come back because the state will dismiss it as long as you give them proof of your
Yep.
driver's license.
Mhm.
So once you get your driver's license, just walk it down or mail or fax it or whatever they accept,
Mhm.
and give them a copy of your driver's license, and then you will not need to come back, okay?
Okay, yep.
All right, so you can come up here and get your notice and you're free to go, and any money that you've paid would be reimbursed to
Okay.
you, okay? Mr. Stanhope? Stacy, Daniel Bruce is off. He's been moved to another day down the road.
Okay.
Mr. Stanhope, I do not have. Who are you? You individuals? It's good to see you, Dr. Otto. Who are you?
Trevor Duran,
Who?
Trevor Duran.
Okay, you're 9:30, and who are you?
David Johnson.
That's right. Okay, so you guys are early. Would we be in victims' rights compliance to be able to go early or no? Well, it's 2 minutes, but
2 minutes,
it should be fine.
Yeah.
Your hair's cute. Okay, let's go with Mr. Durand. We will go on the record in the matter 26 CM 62, State of Wisconsin versus Trevor Durand. The state appears through Assistant District Attorney Jose Vila in person. Mr. Durand appears in person without counsel. We're set for a status conference. I believe at the last hearing, you were not able to issue or to tell him an offer, but was he able to go down and talk to your office?
An offer was made, Your Honor, according to my notes, back on May 27th. It was for him to get the AODA and anger management, and we would do this as an ordinance.
Were you able to do that?
Monday was my last day.
What?
Yeah, Monday was my last day. And
Okay,
Dave said it takes a little while to get the proof through here.
okay, so we're waiting for, Mr. Hatch,
Huh?
Dave Hatch.
Yeah.
Okay, and so, yeah, I don't yet have confirmation. Usually he sends it. And if it was Monday, he could be a little behind. So what we could do is reset this, and at that time, quite honestly, if you know that there's proof, you do not need to appear, because what would happen is the state would go, Judge, I'd like to amend this to an ordinance, and I can say, I find you in default, you're not here, so I'm just gonna assess the money, and then you have bail paid, and that can go, and that can pay for that, and then you wouldn't necessarily need to come back.
I'll call, make sure.
Yes, you can call to
Okay.
make sure, but if you just wanna come, that's totally cool too. Okay, so I can give you a few, well, a few weeks or something, just to make sure that that all can happen. August 24th at August 24th at 11:15. Wait, that's a Schmidt week. August 31st at 1:45. Okay, August 31st at 1:45. That should be plenty of time for Mr. Hatch to send his proof. And for you, you can call the clerk's office or the DA's office to see if the proof has been provided. And then it's your choice again, of whether or not you want to come into court or you don't, because you cannot get a warrant for failing to come to an ordinance. Okay. Okay. So you can come get your notice and you're free to go. Mr. Johnson? Down and slide back. We will go on the record in the matter 26 CM 36, State of Wisconsin versus Jaden Johnson. The state appears through Assistant District Attorney Jose Vila in person. Mr. Johnson appears in person without counsel. We're set today in this matter for a status conference. We are in victims' rights compliance.
Yes, Your Honor.
And offer has been presented.
Yes, Your Honor. The offer for this one was presented back on April 22nd, according to my notes. And that one was to do the anger management class with Mr. Dave Hatch, and we would do a DC for cost only.
Have you done that program yet?
No, Your Honor.
Or are you accepting the offer?
Yes, I'll accept it.
Okay, and so do you understand that it takes, I think, 4 weeks or something to do? When are you going to be able to set that up with Mr. Hatch?
I know previously, I did feel bad for not getting it done by now. I could probably do it from here on out for sure. I do have his number right now.
All right, what I'm going to do is I am going to set this on the Schmidt week because I'm not going to go way too far out. It's just going to be a status for me to be able to check that he's actually doing it and we're moving forward. August 24th at 11:15. August 24th at 11:15, you're going to come back to court and you're going to say, yeah, Judge, I'm doing it. I'm almost done. I have this and I need this much more time. Okay? And if you are accepting the offer, then that would mean that it looks like you have money posted. You should be good. So, the same thing that I said to the last gentleman, if you're done by then and there's proof, then you wouldn't need to come, but I don't think that it's possible that you can be done by then. I'm setting it so close, so quickly, just to make sure that you're enrolled and you're doing that, okay?
Okay.
So come up here and get your notice and you are free to leave.
Okay, thank you very much.
Mr. Howard.
Did you?
We will go back on the record. Same appearances as previously noted. 26 CM, excuse me, sorry. 25 CT 28, 26 CF 94, 26 CT 34. State of Wisconsin versus Zachary Howard. The state, same appearances. Ms. Sherwood, you were able to go over the new charges in the felony complaint as well as you went over the CT charges with Mr. Howard?
Yes, Your Honor, I've gone over the criminal complaint for all 3 charges. We waived the formal readings for both CT matters. We would plead not guilty. We plead not guilty for the misdemeanor matters in 26 CF 94. We ask for preliminary hearing and waive time limits.
Thank you so much. I can set a preliminary hearing on August. Wrong week.
This is
Mr.
technically,
Schmidt week.
yeah. The Mr. Schmidt case, Your Honor.
It's hard when I have visiting judges using my courtroom and time blocked off and I can't use it. Nice when we have two, maybe. Courtrooms. I could do 2 o'clock on August 13.
Mhm.
That works for the defense?
All right, 2 o'clock, August 13. Not guilty pleas to all of the misdemeanors still on Ojibwe Drive.
Yep.
Telephone ends in 8479.
No.
What's your telephone number?
754163219.
We have that in one of our files, so thank you. Can we remove the other number?
Yes, and my minute's actually about to go out, so I'll update the court with a different number as soon as this goes out.
Why can't you keep the same number?
In the middle of jobs right now. I've been more of a stay-at-home father, so I'm about to pick up a part-time job.
I know, I don't understand.
Continue
though,
my schooling.
If you get more minutes for a phone, why do you have to get a new telephone number? Can't you just upload more minutes or pay for more minutes?
That's exactly what I'm trying to do, and if I can't, I'll have to update the court with a different number. It's through an app on my phone that would be for free for me until I get the funds to get my number back working.
Okay, I don't understand that, but okay. It's usually before when you had the track phones and then you buy little cards to get more minutes and you add the minutes to your little track phone, then you can keep the same number. It just adds the minutes to the phone.
I'm on a Verizon plan, and I'm a little bit behind, so it's getting close for it to cut off before I pay for it.
Okay, all right.
Just to update the court, we do hope to have someone assigned to this criminal or this felony matter. Our office is waiting for date of birth for one of the victims so that we can finish our conflict check.
Okay, and so you're not quite
The
certain
13th
that
at
you
2
would
o'clock.
be able to take that felony case?
As soon as we get the date of birth for one of the victims, we can conflict it. If it's not a conflict for my office, it will be my case.
Okay, sounds great. Thank you so much. We'll see you then.
Thank you.
Thank you. We're adjourned.
Thank you, Judge.
Thank you. Mr. Stanhope, can you hear me?
Yes, I can.
You too. We will go on the record in the matters 26 CT 08, 26 CT 13, State of Wisconsin versus Corey Stanhope. The state appears through Assistant District Attorney Jose Vila in person. Mr. Stanhope appears by telephone conference without counsel. Mr. Stanhope, why were you unable to come here to court in person today?
Because the work I laid concrete and there's only two of us, and so I really couldn't afford to not be on the job site.
And you know, I understand that, Mr. Stanhope, but you gotta call a lot sooner than, 10 minutes after your hearing. It has to be at least last week where you say, you know what, Judge, is it possible for me to appear by telephone? That would make my life a whole lot easier because I'm here for operating while revoked and I don't have the ability to drive.
I believe on the paper that I got, it said I was approved to call.
Well, I'm not seeing that.
All right, well, it won't happen again.
I'm looking at the notice of hearing right now and it does not say that you have that ability. All right, so just more notice than 10 minutes after your hearing, okay?
I understand.
All right, so where are you in the process of getting your license? You needed to do an assessment and you were, I think, saving the money?
Yep, I was saving the money. I also had to pay Minnesota $640 because I have to pay over there to reinstate so I can do Wisconsin. So I just paid that. I'm just got to pay Wisconsin and then the assessment.
So how much do you owe Wisconsin now?
Like $400, I believe, plus $300 for a reinstatement. And then The assessment is probably gonna be like 400.
So I need a realistic time when you think you can get all of that done, because I don't want to keep dragging this out.
I want to say like a month and a half. I should be able to have everything paid and the class done.
Okay. October 1st at 2. October 1st at 2. Hopefully you'll have all that done by then, okay? If not,
Okay.
and if you need to appear by telephone, please call, at least a couple days ahead of time, all right?
Okay.
And let's say that you do everything, you get your assessment and you complete everything by that date and time. You should not need to come to court at all if you're able to give a copy of your driver's license to the district attorney, okay?
Okay.
All right, we will see you then.
Thank you.
Thank you. Okay. Mr. Peterson. Yeah, I know, it's like 3 minutes, but usually he's here early.
Did you see the?
Okay. Stacy, we're just gonna take a quick little break so you can have a little break, and then if and when Mr. Peterson comes, I'll come back to court, but if he doesn't come back to court, then I won't get back on until closer to 10.
Okay, and I'll be able to hear you if you start talking.
Okay, thank
I'll
you.
be close.
We will go on the record in the matter 26 CM 64, 26 TR 307, 26 TR 308, State of Wisconsin versus Roger Peterson. The state appears through Assistant District Attorney Jose Vila. Mr. Peterson fails to appear. This matter was set for today at 9:45. It is now 9:55 and no appearance by Mr. Peterson. The court has cameras of the entire building, exits and entrances, and does not see Mr. Peterson in any part of the building. He fails to appear. He had adequate notice of today's date and time. It was set on July 7th when he appeared in person. So the court orally provided it to him as well as in a written form. What is the state requesting?
Your Honor, just for clarification, if memory serves correct, Attorney Larimore appeared on behalf of Mr. Peterson, or was that just a special appearance?
That was a special appearance.
In light of that information, I would ask for a warrant.
All right, the court is going to issue a warrant, $500 cash, only judge may quash or posting of the cash. He will be provided a new date and time upon posting. Actually, I'm going to change that to $1,000. He currently does not have any cash posted. The court is going to find him in default in 26 TR 307. I'm going to assess $200.50, 3 points off of his license. The court will find him in default in 26 TR 308. The court will find him in default for his failure to appear and assess $263.50, no points off of his license. Those must be paid within 30 days. Again, he will get a new date and time upon posting. We are adjourned. Stacy, I think we have to get to the confidential one now.
Okay, Mary.
Judge.
Mr. Chapman?
Mr. Chapman's case will be quickest.
Fine by me. We will go on the record in the matter 26 CF 35, State of Wisconsin versus Leon Chapman. The state appears through Assistant District Attorney Jose Vila in person. Mr. Leon Chapman appears in person with his counsel Daniel Chapman. We're set today in this matter for a status conference. Mr. Daniel Chapman, can you please update the court?
Your Honor, I'm trying to verify a conviction from about 30 years ago, I believe, in North Dakota, 20 years ago. And they tell me there's a transcript available, but they haven't produced it for me yet.
From 20 years ago?
I forget the date, but 1 second. I think it was 2005.
Mr. Vila?
Are you referring to the North Dakota 2011 case?
Yes, 2011, so 15 years. They tell me that there's a transcript. I made a written request. I've been told by the clerk there that it's been referred to a court reporter to transcribe for me, and I have not heard anything back. I did follow up, and they said they would follow up with the court reporter.
Okay, so you just need a little bit more time.
Yes, please.
All right, that's not a problem. Leon Chapman, you're behind on your payments for your attorney, so you're gonna need to stop and see the clerk before you leave?
Yep, I was gonna mention that or whatever, towards the end of the month or whatever, I'll be able to get caught up on that a little bit.
Okay, I'll give you till the end of the month
And
to
that's
do
so-
that. I'll take you for your word, okay?
And then, yeah, because right now or whatever, I currently don't have a job right now, so
And it looks like you're going to be able to get a job soon?
I'm hoping.
September 28th at 10:30. You're coming back, Mr. Chapman, September
Yes.
28th at 10:30.
Thank you.
Thank you. We'll see you then.
She'll give you a notice. You're
Come
good to
get your
go.
notice and you're free to go. Make sure you stop at the clerk's office and talk to Amy, not talk to Danielle. And then just update her and let her know that you talked to the judge and by the end of the month, you'll be caught up. Okay?
The payments I've made so far.
Oh, good. Okay, well, yeah, don't lose those. Yeah, so just update her, because they're the ones that monitor it like every day. And then, so then I won't have to have them hound you, okay?
Got a couple applications out there.
Well, good luck.
Having a single parent and that's that hard to work night shift. Rather than no
How old's your
vacation.
child?
So 5, well, just turned 6, but
That is hard. Hear ya.
pretty much until school starts or whatever, a little bit, and I can get them in there, so.
Well, good luck with that too.
Thank you.
I understand completely. We will go on the record in the matter 25 CM 155, 25 TR 455, State of Wisconsin versus Thomas Towell. The state appears through Assistant District Attorney Jose Vila in person. Mr. Towell appears in person with his counsel, Daniel Chapman. We're set today in this matter for a plea and sentencing. Mr. Chapman, can you please update the court?
We are prepared to move forward with the plea today, Judge.
And has he sat 48 consecutive hours?
He has not.
So, Mr. Towell, do you understand that you would report to jail immediately here today?
Yes, ma'am.
Okay. He's going to plead to the OWI third as well as the possession of THC misdemeanor. Is that correct?
Correct, Your Honor.
I have in front of me a plea questionnaire waiver of rights form. Do you recognize the document, Mr. Towell?
Yes.
Did
Your
your
Honor,
attorney?
It's toll.
Oh, it's toll. I'm sorry.
Okay.
Oh, I should have known that because there's a Russell toll. I don't know if you're
I'm not related.
not related. Yeah, from back in the day. I apologize.
That's okay.
So, Mr. Toll, did your attorney go over with you the plea questionnaire waiver of rights form?
Yes, Your Honor.
Did he essentially go over it word for word?
Yes, Your Honor.
And you understand them completely?
Yes, ma'am.
And did you sign that document?
I did.
And so on this document, it states that you are pleading guilty to the OWI third as well as to the possession of THC misdemeanor. Is that correct?
That is.
You're 48 years old. You have 12 plus years of schooling. You can read, write, and you understand the English language. Is that correct?
Yes.
Did your attorney go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes.
Did your attorney go over with you the maximum and minimum possible penalties that you face?
Yes, Your Honor.
You're not receiving treatment for mental illness or disorder, and no drugs, alcohol, or medications.
Correct.
Because you're charged with crimes, you are entitled to constitutional rights, and each of these rights is listed on this document. Did your attorney thoroughly go over those rights with you?
Yes,
Do you understand them completely?
I do.
Do you need me to go over these rights with you in any more detail?
No, Your Honor.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes,
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
yes,
Do you understand that the state would have to prove as to possession of THC count 3 that on or around June 9th, 2025 in Burnett County, Wisconsin, you knowingly possessed a substance, THC? Do you understand what the state would have to prove?
yes, Your Honor.
Do you understand the maximum possible penalty could be a fine of up to $1,000 or 6 months of incarceration or both?
I do.
Do you understand as it relates to operating while intoxicated or under the influence, while operating a motor vehicle while under the influence, third offense, the state would have to prove that same date, that same time, that same place that you operated a motor vehicle while under the influence of an intoxicant. Do you understand what the state would have to prove?
Yes, Your Honor.
Do you understand that the maximum, or there's minimums and maximum possible penalties, and that upon conviction for this misdemeanor, you shall be fined not less than $600, but no more than $2,000, and imprisoned for not less than 45 days, but no more than 1 year in the county jail?
Yes, Your Honor.
Do you understand that there is an agreement that's been reached with the state, but that I'm not bound to follow that agreement? You understand that?
Yes, Your Honor.
That means I could sentence you to the maximum possible penalty for both of these crimes if I thought it was warranted. Do you understand that?
I do.
Do you wish to proceed and enter guilty pleas?
Yes, Your Honor.
Did you go over the criminal complaint with your attorney? And in particular, there's a section called the probable cause section where it basically says what happened and why you were charged with the crimes.
Yes, Your Honor.
For the most part, are those facts accurate?
Yes, Your Honor.
Mr. Toll, are you pleading guilty to an operating while under the influence third offense because you are guilty?
Correct.
Are you pleading guilty to possession of THC because you are guilty?
Correct.
Mr. Chapman, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you for you to plead guilty today?
No, Your Honor.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Correct.
and voluntarily?
Yes, ma'am.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes.
Has he looked at this matter thoroughly?
Yes,
Are you satisfied with his services?
I am.
Do you have any questions for the court or for your attorney before I proceed?
I do not.
As to count 3, possession of THC, a misdemeanor, how do you wish to plead?
Guilty.
As to count 5, operating while under the influence, third offense, a misdemeanor, how do you wish to plead?
Guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I will find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of those 2 offenses. The other matters will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument and is there a PAC? The court will also dismiss and merge in count 6 with count 5. Argument and sentencing recommendation, Mr. Vila.
Thank you, Your Honor. Mr. Toll is here taking responsibility for his actions. He has since completed the IDIP program and hopefully has learned some valuable programs and resources so that he does not reappear in front of the court in this manner. This is an OWI third with the THC component. As such, if he does choose to operate a motor vehicle under the influence again, his next one's a felony. I think there's sufficient deterrence there for him to try and keep that off his record. As it relates to the THC, agreement here, I believe, is for probation. I think any need to protect the public will be accomplished by that point, as well as the necessary license revocation provisions for the OWI. As such, I would ask the court to adopt. Thank you.
All right, Mr. Chapman.
Your Honor, I want to explain the firearm briefly. Mr. Toll informed me that that gun was not his. He didn't put it in the car, and he had no idea it was in the glove. I think it was the glove box at the time that the officers found it. I know it's not exactly probative beyond a reasonable doubt, but he did tell me who the person that owned the gun was, and I was able to find a police report of that same person being arrested with that same gun recently. So it was plausible. With respect to the OWI, his priors were from 1998 and 2014, so he had 2 prior first offenses, and this will be the first time he's had a criminal OWI. He did his assessment. He's fully employed, he's married, he has 2 children, and has no other record. I also believe this is an appropriate resolution and would ask you to follow the agreement.
All right, thank you. Mr. Toll, is there anything that you want me to know? Anything you want to say here today?
Oh, Your Honor.
All right. Well, Mr. Toll, Mr. Vila said it in his argument to the court, and I'm really hoping that you're going to let this sink in and you're really going to take it seriously. If you get another OWI, that is a lifetime revocation, or could be a lifetime revocation, depending on when your convictions were and what the Department of Motor Vehicles does. And to not have your driver's license in this county is very difficult, especially if you have kids and you're married and all of those things and all that a family needs to do. Operating while under the influence is a serious offense. It's the 3rd offense or conviction for you, so it makes it a little bit more serious. But you are taking it serious and you're pleading guilty, and you want to make the changes and you want to do the things to not be in this position again. Hopefully you have learned, and it's not going to happen, because I really don't want to see you here for an OWI 4.
Me neither.
The fact that the weapon makes complete sense now, and I trust Mr. Chapman when he looks into things and the evidence that he does find. So with regards to that count, I do understand it better now, so I appreciate that. The next time you're in a vehicle, make sure you're not under the influence of anything. And I do have to tell you that THC is illegal in Wisconsin. I don't know if it'll ever be legal. It's only legal in the states surrounding Wisconsin. So if you want to partake in it, I strongly suggest you only do it in those states. But make sure that you're still not under the influence when you come here, because it stays in your system for a very long time. I do think that the agreement is appropriate. I do have to look at the seriousness, and I have to look at you and your history and needing to protect the public. The public will be protected, at least for a period of time. You're going to be punished. You're going to have a sanction. You're going to go to jail. So what the court is going to do is I am going to this was a restricted control, I believe, $1,286 in fines and fees, plus a $10 blood draw fee, 45 days of jail, $24 months revocation of your driver's license, and 25 or 24 months of an ignition interlock device. Are you currently working?
Yes, Your Honor.
All right. With regards to and that's just, I'm doing that as a conditional jail right there, the 45 days, because I'm being asked to place you on probation for the THC. I'm actually placing you on probation for the OWI 30. As well as the possession of THC charge. The THC charge is not going to have any conditional jail attached. I'll place you on 1 year of probation. I'm not going to order the community service because what I'm going to do is I'm going to order that you apply to the Burnett County Treatment Court. And if you qualify, if you're accepted, then you engage in that program. Because quite honestly, I don't want to see you get an OWI 4th. And I don't want to see, because that harms you, it harms your family, and it harms Burnett County. So that's why I am ordering as part of this that you apply to the treatment court. So 1 year of probation. And you haven't sat 48 consecutive hours. So this is an immediate report. You have to report immediately, okay?
Okay.
And I don't know if you asked or monitor, because you did you complete fully the IDIP?
I did.
He has, it's set up for EHM set up on Friday.
Okay, on Friday. So then you can talk to Mr. Hatch when he sets you up about the treatment court and go over that. I will give you the ability to serve your time on monitor. Follow the rules and the procedures, stay away from gasoline, stay away from rubbing alcohol when you have the monitor near you, because it will set it off. And that will mean that it is positive, and you'll be told that you're immediately revoked off the monitor. You must go serve your time with no good time and no Huber. But this is conditional jail, but you'll be out on monitor. Hopefully you're going to do well. I just really want you to do well, Mr. Toll.
I do too.
And I'm going to tell you that if you're accepted and if you do participate in our treatment court, you are going to be one of our first OWI people in 8 years, because we have totally revamped our treatment court for OWIs to include them, because to me and to my team and to our county, those are serious, and we need to address that. So I would be excited to have you in our team, or on our program. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I have to order your DNA. And when you go to the jail, they'll make sure that you take that. With this, I believe you could request it be expunged through a written letter to the Department of Justice, not to the court, to the Department of Justice. You can Google it and you'll see it's very easy to do. You're not working right now?
I am working
Where are you working?
at Ingstrom's.
Oh, okay. That's really good. Okay, at Ingstrom's.
Yeah, your cousin's my foreman.
Yeah, okay. So you work a lot.
I do. I'm missing work right now.
You work a lot yearly,
I'm a lead foreman as well.
and that'll interfere with your ability. Treatment court will interfere with your ability to be able to provide for your family. Because you work a lot. I know you guys do at Ingstrom's.
Yeah, we're pretty busy right now.
You know what I'm gonna do? I'm gonna remove that condition, unless you want to do treatment court, but it's a lot of work.
I would rather just go to work and make the money I need to make.
I want to make sure that you can support your family.
Thank
So what I'm gonna do instead, because I'm changing my whole way of thinking right now. I'm gonna leave you on probation. What I'm gonna do instead is I want you to complete the program with Dave, the skills directed practice program. Okay, I know that you've done other things, and but treatment court takes a lot of time, and I want to make sure that you really have the grasp that and you're not going to do this again. So that's what I'll do. And so you can talk to Dave about that
Okay,
on Friday.
great.
And so payments, are you able to pay that off in full or would you need a payment plan?
A payment plan would probably be best at the moment. I was off of work for 5 weeks because I had my finger amputated.
Ooh, what happened?
A table saw accident.
At work?
Yeah,
Oh, man. All right, and for the,
In case you need to remember it.
for the THC charge, I'm only gonna assess the $200 DNA surcharge since there's a high fee with the other matter. I'm gonna say payment of $250 a month until paid in full. You can have it taken directly out of your check. If you want to pay more than that, great, because then you get me off your back, because not only will I enter a civil judgment against you if you don't pay it, but I will issue a warrant and you could sit up to 6 months in jail. And I do track that, and I'm a stickler at people making their payments because that's part of the sentence. You're going to make the payments here to the clerk, not to Department of Corrections.
correct.
Okay.
Yep.
This program and class, I'm going to say that it needs to be completed by the end of January. So that gives you some time to be able to do that. Mr. Vila, am I missing anything?
Did the court already provide the right to appeal?
Yep, 20 days to appeal. Oh yeah, I'll get to conditions. I do have conditions, I guess, while you're on probation. Conditions of probation: absolute sobriety, no use or possession of any illegal drugs, substances, or paraphernalia. Testing, regular testing to ensure that. Absolute sobriety means no alcohol, no illegal substances. That's about it. Make sure that you get your driver's license. But you've done most of the things, all the things that you need to do. So
Yeah, I
you're
have
doing
one
that.
more class I signed up for and paid for in September coming up.
Okay. Mr. Chapman, what else am I missing?
He has 2 days of sentence credit.
Okay, 2 days of sentence credit, but you have to sit that 48 hours. And once you're done with that, you're going to be good to go.
Okay.
Okay.
This is the moment where the consequences become very real. After pleading guilty, he now has to face the sentence and spend those 48 hours in jail. There's no more room for delay. The decision has been made.
Yes.
All right, thank you. Then we are adjourned.
One more document I need to go through with you.
Okay. Great. Okay. Awesome, thank you.
Last thing I need is, do you know what it means to appeal? Appealing means if there was anything in this process that you wanted to back up and change, you have the right to ask a higher court, Court of Appeals or the Supreme Court, to
I was gonna
undo
do
something,
post, but
back it up
stayed,
and
but-
start over.
I'm not gonna do that.
Okay, I'm gonna check that you don't plan to appeal. But like it says right there, you have 20 days. So if you have questions or if you change your mind, you gotta let me know within 20 days.
Correct.
If you could just sign and date there, it says you understand you have the right to appeal. I'll fill out the rest.
Okay.
Take that. Probation will probably want to see it if they don't print out their own copy,
Okay.
and you are good to go.
Thank you very much.
Good luck.
Ms. Bolio?
Are you gonna take him down or should I just tell him to report John to the jail?
You can just report.
Okay, I'll go tell him just to make sure, but I kind of thought somebody would be walking around.
That's typically how you've always done those. They just report themselves. Right.
Yeah, but if you want to take them, you can take them, or, yeah, I trust them, because if they don't, it's a fleeing charge, so.
Yeah, I would assume that too, but I didn't actually tell him to go right down to the jail, so nobody actually did. I just wanted to make sure that he knew that, that was not negotiable.
Thank you, Mr. Chapman. We will go on the record in the matter 25 CT 56, 26 CM 37, State of Wisconsin versus Marie Bolio. The state appears through Assistant District Attorney Jose Vila in person. We have Ms. Bolio in person with her counsel, Daniel Chapman. Mr. Chapman, this could have been a potential plea. Can you please update the court?
Your Honor, Ms. Bolio has not yet completed the prerequisites. She has to do the anger management program with Mr. Hatch and get her driver's license back, although that is less important. She needs more time to do those things, and she would ask for 2 more months, please.
October 30th, 9:15.
That works for me.
All right, October 30th at 9:15. Make sure you have the anger management completed by then. Hopefully you have your driver's license and we'll be all good to go.
Yeah.
All right, you can come get your notice and you're free to leave.
All right, thank you.
Thank you.
Diligence on that, okay?
Yes.
Stacy, we're off for, I guess we have a chunk of time. So I'm gonna log off and we'll see you later.
Yeah.
All right, something about Miss Simmons. Mr. Harrington?
Yes, Miss Simmons was going to appear by telephone. It says Andrea's phone there, but that doesn't look like an Andrea to me.
Doesn't to me either, and I don't know.
There she is. I think that's an Andrea.
Okay, there we go. Can you hear me, Andrea?
Yeah, I can.
We will go on the record in the matter 26 CM 87, State of Wisconsin versus Andrea Simmons. The state appears through Assistant District Attorney Jose Vila in person. Ms. Simmons appears by video conferencing with approval of the court. Eugene Harrington, Defense Counsel, appears in person. We're set for a status conference. Mr. Harrington, can you please update the court?
Judge, I filed a request for discovery early this morning. I talked to the DA's office about 20 minutes ago. They're going to have the discovery for me. Mr. Vila and I have had a discussion. Mr. Vila actually sent a proposal to me by email the day after I was appointed by the Public Defender's Office. I've had one conversation with Andrea about the proposal, but I haven't heard her version of the facts yet, and I really need to do that. I expect that we'll get these matters resolved relatively quickly. I request that it be set back for a return date, 45 to 60 days.
All right, what is the offer that's been presented?
Plead to count one in the traffic matter, operating while impaired, first offense, and then deferred acceptance of a judgment as to one of the two battery counts, dismiss the other, 1-year contract. For the OWI, be the standard disposition for OWI 1.
I'm missing an OWI. Yes.
That one, yeah, that one should be filed either today or tomorrow morning. We just put the finishing touches on it. I sent it preemptively to Attorney Harrington, so it was on his radar.
Okay, makes sense, because I'm like, I don't have an OWI here.
Neither do I yet, Judge, but you know.
That's the offer.
We'd like to be reasonably efficient sometimes.
Okay. Sounds good. Okay, let's get a date out. I can do October 1st, either in the morning or the afternoon.
afternoon, if I could.
2:15?
2:15 works. Andrea, does that work for you? October 1st? 2:15, preferably come up here.
Okay.
All right.
All right. Thank you.
October 1st at 2:15. All right, we'll see you then.
All right. Thank you.
The status is fine.
How much time you have that day?
Well, the rest of the afternoon's open. Potential plea?
Yes,
Okay.
potential plea.
Yeah, okay.
You off the record?
Yeah. Well,
Thank you for helping me out with my stupid scheduling mistake on that motion. That was, I didn't coordinate one calendar with the other, and I promised my daughter I would help her out.
That's okay. It all works out.
Well, yeah, I appreciate that, but it's important that I say thank you too.
Well, I appreciate that too. Thank you.
All right. Thank you, Judge.
Jose Vila in person. Mr. Natanoki appears in person with his counsel, Nicholas White. We're set here today in this matter for status conferences. Mr. White, please update the court.
Thanks, Your Honor. This is a case that we're working towards the IDIP resolution. Mr. Natanoki has been in contact with Tess Anderson, was directed to communicate with Dave Hatch. Sounds like they have a plan for a meeting on August 12th. So looks like we're about a week away from them beginning the program. I'm not sure where that puts us in terms of just scheduling a status a couple weeks out, or if we should just put it on for a plea hearing about 2 months out. I'd be okay with either one.
Mr. Natanoki, I think we talked about this at the last hearing, that you were supposed to have signed up and gotten everything ready to go by this hearing.
Yeah.
What was the holdup?
Just I tried getting in contact with them beforehand, but they kept just redirecting me to like back and forth to Tessa, to pretty much like the same people that was mentioned before, and they just kind of said the same thing, just like, yeah, you just got to get everything set up before you can, you know. So I just said, let's just hurry up and get this get me enrolled so I can just get through this.
Start?
Yeah, so I can start. Exactly.
Mr. White, I would like to have a status, and you can appear by Zoom. I just need to know if he's actually doing the program, because I'm not going to keep waiting and prolonging the case. Can you do August 31st at 2 o'clock? And we can set a tentative plea too, because here's what I'm going to do. We can schedule that, and Mr. White, if Mr. Natanoki informs you that he's already enrolled and he's doing the IDIP, that can come off. I just want to make sure that this is progressing.
Yeah, that time will work, Your Honor, and we'll try to keep in touch about his progress.
And so if you want to set a tentative plea hearing, we could do that. October 15th at 1:30.
Your Honor, I should have time that day if something's scheduled now, but I think that'll come off. So 15th at 1:30 works.
Okay, October 15th at 1:30. Mr. Natanoki, you can come and get your notice. Thank you.
Do you still want the review on the August 31st?
If he gives you confirmation that he's in IDIP,
Okay.
then it can be removed.
Okay.
That's only set because I want to make sure that he's enrolled and doing what he needs to do. I don't see Mr. Lightfeather. Would you like to try and call him?
Your Honor, I haven't been able to reach him. Just call me once you
Do you have any other clients? Doesn't look like it.
No.
Other than Lightfeather.
No one for
All right,
hearing.
we will go on the record in the matter 25 CT 33, 25 TR 492 and 493. State of Wisconsin versus James Lightfeather. The state appears through Assistant District Attorney Jose Vila in person. Mr. Lightfeather fails to appear. These matters were set for statuses. We have Nicholas White, his counsel, making an appearance here today. Driving is good. It was set for 2:45. It is 3:03 and no appearance by Mr. Lightfeather. He doesn't appear by video conferencing nor in person. The court is looking at all of the video cameras, entrances and exits, and I do not see Mr. Lightfeather. What is the state requesting?
I would ask for a warrant, Your Honor.
Court will issue a warrant, $1,000 cash. Only judge may quash or posting of the cash. He will be provided a new date and time upon posting. As to 25 TR 492, failing to keep vehicle under control, the court is going to default him and assess $213.10, 4 points off of his license. As to 25 TR 493, failing to stop, the court's going to default him and issue an amount of $175.30, 3 points off of his license. Mr. White, if there isn't a reasonable excuse, a very good, reasonable excuse as to why he's not here, I may reconsider, especially perhaps reopening the 2 tickets.
Okay.
So if you hear from him, please notify the court.
Understood. I'll do that. You might see him before I do. So,
All right, thank you. We are adjourned.
thank you.
And thank you, Mr. White. Mr. Rapley. We will go on the record in the matter 26 CM 88, State of Wisconsin versus Derek Rapley. The state appears through Assistant District Attorney Jose Vila in person. Joe Feliski, Defense Counsel, appears in person. Mr. Rapley appears by video conferencing with approval of the court. We're set here today in this matter for a status conference. Mr. Feliski, can you please update the court?
Thank you, Your Honor. The state has made an offer to resolve on this file, proposing that Mr. Rapley plead to either count 1 or count 2 of the complaint. The parties would be making a joint recommendation for court costs, a time served sentence, dismissing and reading in the other count. I've relayed this offer to Mr. Rapley and discussed it with him. Based on that discussion, I do believe the parties have reached an agreement. Understanding the nature of the case, at this time, I would ask for a plea and sentencing date to be set out on the calendar.
All right, Mr. Rapley, if that is your intent to accept the offer, it wouldn't involve a recommendation to the court of probation. If the court does not place you on probation and it is a court costs only matter, you would need to prepay $443 for the fines and fees. Excuse me?
Your Honor, just for the court's knowledge, Mr. Rapley is already on supervision.
Oh, well, that's good to know too. So, Mr. Rapley, when will you be able to save up $443?
I should be starting working here soon. I'm filling out my I-9 form because I messed up on it. But I should be working here by Monday, so within a couple weeks.
So do you want this resolved sooner rather than later?
Yeah.
All right. And then I am going to have to tell you though that does need to be prepaid $443. If it is prepaid prior to this hearing date, you do not need to come here in person.
Okay.
Okay?
Yeah, it shouldn't take me nothing but a couple weeks to at least be able to make some type of payments towards it.
All right. Does August 27th sound too early?
Yeah, I think that'd probably be a little too early right now. What's the date? The 5th. 3 weeks.
I can do September 10th at 2:30.
Yeah, that works a little better. Yeah.
Unfortunately, it is a Mr. Schmidt week, but that's what I have. Does that work for you?
Yes, Your Honor.
All right. September 10th at 2:30. All right. Thank you, Mr. Rapley.
All
We
right.
are adjourned.
All right.
Mr. Young. How's your mom doing?
All right, yes, but
Is she home or
yeah, but she's always searching for words, you know, she starts talking and stuff.
she's what?
Searching for words, she knows where things are and stuff, but she just can't. We were taking her back up to emergency after she got out of the hospital. Doctor said, no, there's no use because all her tests coming back normal. It's just old age catching up to her.
Well, I'm sorry to hear that she's declining. We will go on the record in the matters 25 CF 174, 26 CF 49, State of Wisconsin versus Dennis Young. The state appears through Assistant District Attorney Jose Vila in person. Mr. Young appears in person with counsel Joe Feliski. We're set today in this matter for status conferences. Mr. Feliski, please update the court.
Thank you, Your Honor. I am pleased to report it seems the parties have reached an agreement for Mr. Young to plead to count 1 and count 3 of the complaint in 25 CF 174 for costs only, with the option, were he able to get his license reinstated, to have the OAR, the count 3, dismissed. So at this time, I've discussed this offer with Mr. Young. I've discussed kind of the course of the negotiations here with Mr. Young, and I believe that he is comfortable proceeding with this offer. What I would ask for the court to do is to have a plea and sentencing date set out some ways on the calendar, and I'll explain why. In discussing this case, specifically the matter of getting his license reinstated, the last time I had spoken to Mr. Young, it was my understanding he'd contacted the department and essentially had several $1,000s in fees to pay for that reinstatement. In discussing it with him, I've gotten some better clarity, I should say, on the situation, and it seems that what he's required to do is to have his payment plan first set up and then to begin making payments on that. He's anticipating having the first payment within 8 to 10 days, within about 8 to 10 days of today's date. Once that happens, it's my understanding, from his understanding, that the state would lift the administrative hold, so to speak, on him having his license reinstated. So the parties have reached an agreement. I'm just asking to have this set out some ways to give him that opportunity to have that license reinstated.
October 1st enough?
I think that would be plenty of time. Would that work? Okay.
October 1st, I can either do 10 o'clock or 2:30.
2:30 would work.
All right, 2:30 on October 1st. All right, you can come get your notice and you are free to leave. Mr. Feliski, was that your last matter?
Yes, Your Honor.
All right, an extensive, significant delay in this matter from the beginning to finally the end. Josie, there were multiple times and where I would define it as you absconded. You failed to appear for court for very lengthy periods of time. A lot of money had been forfeited to the county, which would be at your expense because it was a lot of cash. I'm not even sure if we have any cash still posted, but the clerk will let me know during the process of this hearing. You pled guilty way back on November 20th, 2025. The court ordered a pre-sentence investigation report for those 2 felonies. One is a second-degree recklessly endangering safety, Class G felony, and the other felony is vehicle operator, flee or elude an officer. The court has received and reviewed the pre-sentence investigation report. Again, that took a lot of time and effort due to the fact that it was ordered, they weren't able to get a hold of you, you didn't contact them, you absconded, and that happened at least on 2 occasions that I can recall. Mr. Schmidt, did you receive a copy of the pre-sentence investigation report?
I received it. I reviewed it. I have no corrections.
Did you receive a copy of the sentencing memorandum filed by defense?
Yes.
Okay, Mr. Feliski, did you receive and review the PSI?
That is correct, Your Honor. I reviewed it with Josie, and we do not have any corrections to make at this time.
All right. Josie, did your attorney go over that document, this one right here, this big, thick document with you thoroughly?
Yes.
And you could not find any material errors that would need to be corrected?
No.
Okay. All right. So I'm going to start with you, Mr. Schmidt, sentencing recommendation and argument.
Thank you. State's going to be recommending the court follow the Department of Corrections recommendation. The court should order 1.5 in, 2 out on the fleeing, should order 3 in, 4 out on the reckless. Those counts should be concurrent to each other because they were part and parcel of the same action or series of acts on the same day. They described the same conduct. They should be consecutive to any other sentence in Wisconsin or Minnesota because they are distinct acts in a distinct state. I start first with explaining why probation should be rejected. First off, this is Smith committing their 3rd fleeing offense. They have 1 prior criminal conviction for it and 1 prior adjudication of delinquency for it. This offense was committed while on supervision for one of the fleeing offenses. Probation is a consequence for a crime that you're already on probation for, and you do it again it's nonsensical. That is the clearest sign that probation unduly depreciates the seriousness of the offense. Furthermore, Smith's history clearly demonstrates that they're just not amenable to supervision at all. At age 25, Smith has 10 prior criminal convictions, counting these 2 today, and 9 prior juvenile adjudications for crime. That's 19 convictions or adjudications over only 13 years. When you go down and read through that sentencing, what do you see? In the criminal cases, you see probation ordered every single time, 8 times convicted prior to today. Smith was given 8 orders of probation. Smith has persuaded adult courts to place them on probation every single time. 8 times Smith has been ordered, to work with agents, to deal with substance abuse, to deal with mental health, to deal with cognitive issues. 8 times it's failed. CCAP and MCRO are useful in figuring out why. And that's because Smith simply doesn't participate unless they're physically forced to. MCRO and CCAP show countless failed court appearances while the cases are ongoing and probation violations once they've concluded. Smith's own stated reason in our case for fleeing the police was to avoid those consequences. Smith had 3 different Minnesota warrants out for her arrest when this fleeing happened. In our own case, even, it took 4 warrants across 3 years to force Smith here to this table at this moment. The court gave Smith a big leap of faith when it allowed her to stay out and go to that treatment facility while waiting for the PSI. And Smith demonstrated why she's not amenable to supervision when she didn't come back when she absconded. As a result, probation is not appropriate for this offender. There's no reason to think that she will comply when there's a decade of history telling us otherwise. Smith needs treatment, and this needs to happen in a confined setting. I find it strange that Smith related to the PSI writer that they didn't believe incarceration is effective at changing people's behavior because, like I said, Smith's effectively been on some form of supervision for 13 years, going way back into her childhood. She's not been given incarceration. So to conclude it's not effective when what you're asking for has itself not been effective doesn't make a ton of sense. It should be no wonder that Smith has continued unabated in her behavior because she's simply not been held accountable. The only time she's gotten incarceration, it's been as a revocation or a DOC action for noncompliance. The PSI talks about some of Smith's challenges, her criminogenic needs. Smith has a family that has a lot of members who have been involved in criminal activity. She talks about that in her own, how that's affected her own struggles in the PSI. She grew up with said family and said that they made drugs available to her, causing early life addiction issues that continue to this day. She has mental health struggles. At 25, she's seemingly not ever worked a job ever. These are all things that can and should be addressed when considering the character of the offender. These are obvious things that need to be dealt with to deal with the idle hands issue that I think is a cause of a lot of this crime. Those issues should be dealt with though in prison though, because prison does have resources that Smith hasn't tried. Being on supervision one way or another for 13 years in Minnesota, where they have far more programs than us, she's exhausted everything. Even beyond that though, there's profound need for deterrence and punishment in this case. To me, the number one thing I look at when I'm reading a PSI is the offender's version of their prior history. What a person thinks about what they've done in the past and how they talk about it now in the present tells you a lot about them. It tells you what is important enough to them to remember that they talk about later, how it affected them. This tells you about cognition. It tells you about criminal thinking. It tells you about consciousness of guilt. It tells you how they're going to think about this case in 5 years and 10 years. To the defendant's credit, she does appear to take responsibility for, without making excuses of her adult criminal history. That's more than we can say for a lot of the people that come before this court. However, the defendant claims they don't remember any of the incidents that happened when they were a juvenile. I find this concerning for two reasons. One, that juvenile record was not that long ago. This defendant's only 25 years old. It was not, it was too long ago is not a viable excuse for not remembering. However, the main reason I'm really concerned about this is because Smith's juvenile record, I'm sure the court's noticed, is categorically different from her adult record in that the juvenile record is mostly victim cases. It's assaults, it's thefts, it's crime damage, it's arson, offenses where those should be the ones you do remember. Those are the ones you hurt somebody either physically or financially or emotionally. Those are the ones where if you have empathy and consciousness of guilt, you relate back, wow, I did this terrible thing to that person, that hurts, I want to change who I am as a person. Not these fleeings or a simple possession or something like that. There's indication in multiple places in the PSI that Smith would want to address issues and change herself, but none of those really seem to be in connection with remorse or feeling bad. They seem to be connected to improving her own experience in her own life. Looking at page 10 in the PSI, the defendant says she expresses remorse, but only talks about wanting to achieve better outcomes in her own life in terms of rehabilitation. To that end, what is left when you have a person who's been supervised constantly through various forms of adult and child supervision over a decade, and it continues to fail? You do incarceration. That's what Minnesota finally did after many years in their most recent probation revocations. According to the PSI, if the court orders incarceration up front in this case, it'd be the first time ever that any court has done so in Smith's life. The only time she's ever gotten any sentences, like I said, been on the revocation or been on some sort of a hold while waiting for treatment or something like that. It'll only be the second time she's ever been ordered to prison. It is unfortunate that Smith's been allowed to accumulate this kind of history in Minnesota. It would defy the sentencing factors in Wisconsin for a person to accumulate this many convictions and not get any incarceration. And the Cleary-Gallion factors wouldn't allow it. These cases and what these convictions are for and the non-appearances all reflect a deep cognition issue that doesn't really get addressed in the defense sentencing memorandum at all. The defense sentencing memorandum really just talks about substance abuse and another issue, which I'll get to later. When treatment fails, when cognition is contaminated with what I kind of view in the PSI and the offender's version of, what happened and what to do next and what their goals are, it reads like me. It reads like somebody who isn't thinking about rejoining society for the purpose of helping others or feeling bad about the victims in their cases. To that end, that's why you need specific deterrence in cases like this. If you have an offender where those drivers that we usually rely upon for people to modify their behavior, empathy, consciousness of guilt, just feeling bad for your own actions is how I describe them. Those things you hope that get instilled in children at a young age. When those aren't happening, when they've already had all the attempts being on supervision, whether probation or court supervision, where they've had the option of going to treatment centers and having doctors and having agents with them to work on them to accomplish conditions of supervision, when that just fails over and over, that's when you need specific deterrence. That's when somebody isn't being motivated by the carrots and they need to be motivated by the stick. And this is one of those cases. It also leads me to general deterrence and punishment. As I said previously, this is the third time that Smith has been either convicted criminally or adjudicated delinquent of fleeing. This fleeing involved throwing large objects into the road. One of them was described to me by Deputy Moe as like a metal ramp that sparked as it hit the road. Deputy Moe said that Smith threw it into the middle of the road and he had to make an abrupt movement to avoid it. If he had made a mistake, if he had not reacted quickly enough, one of these objects could have been struck by him or a different police officer at the speeds they were going. They could have died. That's the essence of what the reckless is. The reckless is creating a risk of death or grave bodily harm. In this case, it was to a police officer just doing his job, trying to arrest Smith on a warrant that resulted from her own behavior, from not cooperating with supervision over in Minnesota. Smith admitted they were fleeing to avoid consequences and said she was high on meth while fleeing. That reckless conviction exists because the way Smith chose to go about fleeing this time was so much more dangerous than a typical fleeing we see in this county, than her past fleeings. Other people in the public have to be deterred, and quite frankly, the need for punishment is the reason why the recommendation here for a high-end fleeing sentence and a mid-range reckless sentence is being recommended, because the gravity of this offense, the way the reckless and the fleeing exacerbate each other, aggravate each other, is the reason why. This was a fleeing where the driver's speed was high. It varied between 40 and 69 miles per hour, where Smith would only slow down when throwing objects out of the vehicle. She blew stop signs. She crossed the center line. The vehicle only stopped because Smith disabled it herself while trying to get into the ditch to avoid a spike strip. Smith fled on foot afterwards after the vehicle wouldn't move anymore. Chase was over 10 miles. And it's a chase that endangered the deputies, as I described before, with the throwing of objects. This is not a young first-time offender who made a one-off mistake, who acted outside of character because of some underlying issue that heretofore has never been addressed before and is easily fixed. This is a 25-year-old person who has, despite 13 years of some help, some supervision, some court conditions, has continued to be a risk to the community, has been escalating in the risk to the community with this fleeing, who continues to ignore supervision and rules of courts. The courts have uniformly given Smith up to this point second, third, fourth, eighth chances, and now Smith is asking for a 19th one if you count the adjudications. McCleary-Gallion factors demand more. The character of this offender is such that prison is necessary. Probation would unduly depreciate the seriousness of this offense, and the court should follow the recommendation of 1.5 in, 2 out on the fleeing, and 3 and 4 out on the reckless. Finally, there's one thing I do need to comment on from the sentencing memorandum that I have a serious problem with. The defense sentencing memorandum makes arguments that use the defendant's gender as a basis. That memo argues prison is not safe for transgender people, that prison cannot allow Smith to navigate her gender identity. To that, I have 2 main responses. One, it is ridiculous and without evidence that the Wisconsin prison system cannot accommodate transgender people. It can and it does. The prisons are safe, probably safer than outside the prison because of all the supervision and control of inmates. This is a perpetuation of movie stereotypes that is wrong and harmful. Second, it's illegal for courts to consider gender as a sentencing factor in Wisconsin. It is categorically an improper sentencing factor, just like race or religion. The Supreme Court of Wisconsin explicitly held that gender cannot be considered in State v. Harris, 2010 WI 79. Any argument based upon Smith's gender should be disregarded by this court. It has no application to sentencing in Wisconsin. Thank you.
All right, thank you. Mr. Felisky, before I ask for your argument and recommendation, what is the jail credit?
Thank you, Your Honor. I have the following totals from a review of this file. It appears that initially Josie Smith was brought into custody on May 2nd of 2023, then posted cash bond on May 9th of 2023. She would have 8 days of credit from that time. She was then brought in on a warrant. I believe that was served and executed on January 31st of 2024. I then note here that bond was posted on February 5th of 2024, making for 6 days. Lastly, she has the current period of incarceration that she's been serving from May 26th of this year up until today's date, which would be, by my math, 69 days. So all told, by today's date, she would have 83 days of credit. I've relayed and discussed this with the state, and I believe that is the party's stipulation. Yes.
Okay, thank you. And it's my understanding that Josie is still on supervision from the latest Minnesota conviction from June.
I believe so, Your Honor.
At least that's what the PSI is stating, and no one corrected me. All right, thank you. Argument and sentencing recommendation, please.
Thank you, Your Honor. I think certainly when we look at this situation, it is quite serious. It would be quite serious if it was a first-time offense. It is certainly serious as it is now. It involves a high-speed chase with law enforcement over several miles, at which point several items were thrown out of the window. It is serious. And I don't think that Josie is under any impression otherwise. In discussing this case with her, Your Honor, and discussing this sentencing, it's been very clear, been made very clear to me that she understands that this is the last stop. There are no further chances that are going to be coming after this. Her record is quite long. It involves serious offenses. It involves offenses of a repeated like nature. She understands that after this point, frankly, since she's been an adult, and arguably before, there are responsibilities towards participating in society that she has not upheld. She's engaged in antisocial behavior and has received punishment to that effect. She has been put on supervision, as has been noted by the state. She has been revoked off that supervision multiple times in Minnesota. In fact, in looking through the packet and looking through the length of this case, it seems there were some significant periods of time in which she was serving out revoked sentences in Minnesota. I say all that, Your Honor, because I think the state's perspective on Ms. Smith is that she's someone that doesn't get it. She's someone that hasn't been able to get it. But in speaking with her and in discussing this case with her, Your Honor, I do believe that thankfully now finally has come the time where she understands that this behavior cannot, should not, and will not continue. She understands and is very open to me about the remorse that she feels for the situation. It's regrettable that it ever got to that point to begin with. But I think looking at that situation, Your Honor, and then looking at Ms. Smith's adult history, I think there is a clear through line here, and that clear through line is substance use. She's advised, and as was outlined in the defendant's memorandum, substance use has been a factor in Josie's life from a very young age. She was exposed to and given substances by people that she should have trusted. And I say should have trusted, Your Honor, because these were not people that she actually should have trusted, but she should have been able to trust them because these were people in her life, authority figures, family, who should have been there to look out for her, to look out for her going on the path that has led her up to this point and acted to steer her away from that. Now, I certainly don't think that that makes for an excuse, Your Honor. I don't think that that justifies what happened here or what has happened in the course of Ms. Smith's life. But I do think when we look at her character, her conduct overall, the reason that she is coming back before the court, that she is having difficulties in adjusting to supervision, the reason that she is getting new court cases is because of this underlying issue. I think thankfully, Your Honor, this last period of incarceration has in some ways been a blessing for Ms. Smith. It has been a period of enforced sobriety for her. It's been a period where she's been able to clear her mind and really understand the gravity of what has happened here, the gravity of what's occurred over the course of her life, in this case so far, and what she needs to do to avoid that going forward. As a member of the Mille Lacs Band in Minnesota, Your Honor, Ms. Smith is, again, in somewhat of a lucky position. She has access through her connection with that community to resources that frankly make the resources that someone else in that community pale in consideration. There's simply more funding, more programming that's available for her as a member of that tribe. So I think looking at the situation overall, Your Honor, looking at the reason why Ms. Smith keeps on coming before the court, the reason why she keeps having these issues in adjusting to supervision is by and large from an inability to address and move forward from an issue of substances with narcotics. While there is certainly programming available in the state prison system, Your Honor, it, I would say, pales in comparison to what is available and accessible to Ms. Smith when outside of custody. Excuse me. I'd also note that, frankly, in looking at Ms. Smith's history, looking at her connections to this area, to Burnett County in particular, what I have noted and noticed is that she is, by and large, a resident of the state of Minnesota. She has connections in that state. That is where her support network is located. That is where she has built her life, so to speak. I think creating a connection here with Wisconsin, Your Honor, would perhaps be a mistake, given that she has built up this connection, this relationship with her home state, such that presumably the ability to access the resources that she does need to address would simply be much more straightforward. So I think looking at the situation overall, Your Honor, while I do understand the hesitation regarding the history here and the severity of offenses to probation, frankly, I think that, frankly, she's a good candidate because of these underlying needs, because of the fact that she has this clear issue, I would say, with addressing and maintaining her sobriety and proceeding down for recovery. So based on that, Your Honor, what I'm asking the court to do is to sentence Ms. Smith to a period of incarceration in the jail for 110 days, with eligibility for good time, on both counts here, concurrent with each other, consecutive to any other sentence that she may be serving. Thank you.
All right, Josie, I see that you have a paper and it looks like to me you wish to make a statement and you wish to read off of that statement. Is that correct?
Yes, Your Honor.
I'm going to ask you that if you are going to read a statement, first off, Mr. Flisky, please make sure that the microphone is closer to Josie's mouth. Second of all, Josie, please speak loudly, enunciate your words, okay? You need to speak slowly as well because my court reporter needs to take everything down, okay?
Okay.
Also, before you proceed, what is your contact, your relationship with Burnett County?
I have some family here, but not a whole lot. It's on my mom's side, but I don't have much connection to Burnett County.
So family, you mean close family members or just distant family members?
Distant family members.
And so you don't see them very often, if at all?
No.
You have no reason to come into Burnett County?
No.
So if the court were to say no contact with Burnett County, you would not have a problem with that, correct?
No, I would not, Your Honor.
All right, Josie, continue.
Dear Judge Mogan, I'd like to start off by saying how sorry I am for my part in taking so long to realize how much time it's taken to get this case settled. I realized that I made so many mistakes that I cannot change, but learn from it. I've been so hard on myself, and I know that just because of my past doesn't mean it's too late to change my future. I have so much to live for and do with myself instead of repeating past behaviors. I've learned that No one will or would judge me if I have to ask for help. I've always thought about others. People treated me different if they saw or knew that I needed help. But truth be told, it shouldn't matter to them because they don't know my whole story. And it doesn't matter what they think. I struggle and I struggle, but knowing or by thinking I know how to help myself, I didn't. I know now that maybe it's better if I get help from someone professional, or just maybe I can have the chance to get a better outcome. I've had some time to think of a plan for when I get out. I have plenty of resources and structure and people to stand by me and help me get through this that I didn't realize I had, and I don't have to go through this alone. I also understand that this is a serious and take full accountability for my actions. I didn't intend on hurting anyone but by my actions. I do see now that I could have, anyone including myself could have been seriously hurt. I don't like knowing that I was the person putting others in danger. I hope you know that I'm really sorry for my actions in putting the police officers and myself in danger. I've learned a lesson that by the path I was going down would not end well for me, and that it's not too late to take a better one. As soon as I get out, I also plan on seeking help for my mental health. For my depression, I plan on seeing if there are medications that can help with my mental health. I know that things like medications take time to start working, but I like to start somewhere. I made a few phone calls to get into a program called the RNG Bin Magazine. Provides.
Can you just repeat that, please, and very slowly, because I'm not sure if I'm hearing it correctly, and my court reporter does need to make sure she understands as well.
RNG Bin Magazine. It's spelled ANJ.
I have it. It's a double A too. I'll tell the court reporter how to spell it.
Okay, sorry. It provides sober living, work options, treatment options, and helps with college options. All that can help with my journey on recovery that will be beneficial for me. I'm planning on getting a Rule 25 as soon as I'm released. If I have to cut people out of my life that aren't fit for my journey, then I'm willing to do so. I just want to do right, and I want to prove to myself that I can do it.
Thank you, Josie. Is your address still in Grace Lake Road?
Yes.
Is that a parent's address?
Yes.
All right. Okay. I have reviewed the pre-sentence investigation report and the sentencing memorandum that has been provided by the defense. I have been struggling with this case, Josie, simply because you had your initial case, the 22 CF 120 case, which was serious enough. And then a year and some down the road is when you engaged in this conduct, very serious, dangerous conduct. And you received all of these charges, 10 actually, 8 felonies and 2 misdemeanors from the conduct on May 1st, 2023. The most frustrating part about your case, Josie, not only that you engaged in this kind of conduct to begin with, but there's those underlying issues that the court and other parties can understand, the substance abuse, okay? But the most frustrating part is how you would come to court, then you abscond and go away for a long period of time. Then you'd come back and say, Judge, I'm going to be better. I want to work this out. And then you'd disappear again. And then you'd come back and say, Judge, but really this time I really want to. And then you'd go and you disappear again. And this is we're dealing with a 2022 case where it initially started. And the 2023 case, we're dealing with cases that are 4 years, 4 years old. That should have been resolved a long time ago. They were way back in the beginning. It's just that something would happen and you would flee or you'd go abscond and you go engage in this other kind of behavior. Lucky for you, you didn't rack up a whole another sheet of crimes. I mean, there was a lot in there from the time that you were charged with our cases. But hopefully you're on your path to figuring it out. Because if you don't, with all of the things that are going on, Josie, both what you're displaying outwardly, but most importantly, what you're feeling and going through inwardly, it's going to destroy you. You have to work through those, and you have to start with going to the healing center, working through your traumas, discussing what you are experiencing and feeling today as Josie, all right? And that kind of situation before you can change yourself. And you did hit it, the hammer right on the nail when you were stating that, you know, maybe I can change the people that I hang around with, and I probably should. Because Josie, you have to change your habits and the things that you do, and you have to change your associates, the people that you hang out with, in order so you can change yourself. You have to be able to do that. That's where you start, changing your habits and the things you do, and changing the people that you give yourself to, you give your time to, your energy to. That's the only way you're going to significantly improve your life. And if you don't modify and make those changes, I hate to see where you're going to be in 5 or 10 years. I hate to see that. The court has to look at the seriousness of the allegations, the nature and gravity of the offenses here. And the court looks at all of the charges that were dismissed and read in, including the charges that you were convicted of, and to see whether or not there's an aggravation there. And there is, with all of these felonies and all of these serious crimes and the conduct that you engaged in, it does aggravate it. I have to look at your character, your past criminal record. I have to look at needs for your rehabilitation and protection of the public. And as Mr. Schmidt touched on, I have to look at this thing called deterrence. So what sentence is going to finally deter Josie from continuing down this path? And what sentence is going to deter others from doing similar things? Because if the court were to look at a lesser sentence, a smaller sentence than what's recommended here, well, let's say a very small sentence. We'll start at the short end of what defense argued, 110 days, concurrent with each other, but consecutive with any other sentence. If the court were to look at a sentence structure that is that small with the actions here, it would unduly depreciate the seriousness of the offense, and it would not deter others from doing this. Because if we look at this, the charges alone that you pled guilty to and you're convicted of, that was extremely serious. Speeding down a roadway, a highway in Burnett County, and throwing things out of the car to try and evade and flee the officers. Where Mr. Schmidt made a very good point that if something were to be thrown out of the vehicle and were to hit the officer's car going at a high rate of speed, anything could happen. The officer could swerve and hit a pedestrian, could hit a different vehicle, could hit a house. The officer could die. Innocent people could have died because of your actions and conduct that day. So that's where the court has to look. Are we looking at a punishment in the lower end, or are we looking at the higher end of a sentencing? This is serious. And it should deter not only you, but it should also deter others from thinking that this conduct and this behavior and doing these things is okay. The court will not look at probation. I have looked at it first, but I will not order probation because, as I stated, it would unduly depreciate the seriousness of the offense. So the court has to determine, is this going to be a straight out jail sentence, or is this a necessary prison sentence where you need more structured supervision and someone else from Minnesota, because you're not from here, so you would be asking to have, through the interstate compact, your probation or extended supervision in Minnesota, but to have somebody else oversee you to make sure you're doing what you need to do. Josie, you're in the driver's seat. You're in control. You have to make those choices and those decisions. You have to. You are at this age where your brain is finally starting to fully develop, and you're starting to be able to think like an adult. You have to now start thinking clearly. Is this where you want to be in 2 more years, Josie?
No, I
you don't. Is this where you want to be in 5 years or 10 years? Or is this where you want to see your friends or your family in something in a chair right there,
No, I
waiting
don't.
to determine if you're going to go to prison?
No.
In front of the court, you have appeared that you have a kind and gentle soul, demeanor, but you are letting your internal demons destroy you. You are. I do understand you've had a lot of trauma in your life. I've read it in the black and white, and I've heard some from you throughout these years. You can't let the trauma continue to dictate and to control your life. You have to do that. You do need some kind of treatment. And you do need to take that seriously. But again, only you get to make that choice. I have to look at protecting the public, and here, quite honestly, in my view of protecting the public, it's protecting Burnett County, the residents of Burnett County, and then I guess bleeding over to all of Wisconsin or there. And I know you have connections with Sawyer County, you have connections with Burnett, probably through family in both areas. But I do need to look at protecting the public. And so that's where the juggling comes in of, do I look at a lesser sentence or do I look at all the way to the maximum possible penalty? But I have to look at a sentence that is minimal enough to deter you and to look at the seriousness of the crime without going beyond and being too harsh. Now, in reading the pre-sentence investigation report and hearing the argument of the state, it makes a lot of sense. Look at what you've been doing. You have continued to engage in these serious crimes. You've been to prison. You're not being held accountable. You're not taking responsibility. You continue to let your life be taken over by other people and their choices instead of making your own choices. So a prison sentence makes sense. However, there are other factors here as well. Your attorney did hit on some good things that you are finally in a place where you're realizing that you need to do something, or God forbid, you won't be around if you continue to engage in this type of behavior. Prison would be the least of your concerns. I don't want to see that, Josie. I don't want to see that. So I am looking at the middle ground of a sentence, something that would protect the public. It would address the seriousness of these offenses. It would look at your character and your past criminal needs and look at your need to rehabilitate, all right? And look at you as an individual person. So based upon that, what I am believing is an appropriate sentence. I don't believe that you need to have any continued contact with Burnett County. You don't need to have contact with Wisconsin. You can live your life and do what you need to in Minnesota, but you do need to be punished for your conduct and your behavior involved in this case and the 22 case. So what I am going to do is I'm not sending you to prison. So this is a blessing to you, Josie, right now. It is a blessing because you're going to get the punishment factor and the sanction factor, but you're also going to be able to figure out a life plan and follow that yellow brick road to what it is that you want to see your life be and for you to become. But I do think it is serious enough to sentence you to 1 year of jail, of county jail. Okay, 1 year. There will not be any ability to have the electronic monitor because I don't trust you. Sorry, I don't. And you're shaking your head up and down like
I understand.
it's fair, right?
I understand.
So 1 year in the county jail, that gives you enough time to sit and to think and to figure it out. And it is consecutive to all other sentences. And it is each charge, each count has 1 year of jail concurrent to each other, but consecutive to any other sentence that you would be sitting, okay? $518 in fines and fees. I am also going to do a punishment factor on the financial end of it. $1,982 for each count in a fine. Because you failed to come to court, you failed to take care of this and handle this, and yet you missed court and absconded and were in custody somewhere else when you shouldn't have been, and the court did not even have to allow you to appear by video. But I believed you, Josie, when you said you want to make these changes and you want to do better. I believe you. But you have to grasp that hard, and you have to take control and ownership of it. I can't want it for you more than you do. Mr. Felisky can't. No one in this courtroom can want it more than you, because you're the one who has to do it. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. No use or possession of a firearm for life. No voting in any election until your civil rights are restored. That does not include tribal elections. You have to speak with your tribe if you are having an election, whether or not they would permit you to continue to vote. I believe a lesser sentence would unduly depreciate the seriousness of the offense, and it would not protect the public. And it's a punishment portion I believe that covers everything. Mr. Schmidt, what am I missing? Oh, 89 days of jail credit, 83 days of jail credit. No contact with Burnett. Don't come to Burnett, okay? Because if you're not doing well, I don't want to see you again.
I don't plan on.
But I want to know if you're doing well, okay? So, Mr. Schmidt, what am I missing?
Nothing from me.
Mr. Felisky?
Nothing further. Thank you.
All right, then we are adjourned. Thank you.
Thank you.
Mr. Kisslinger, why should I not issue a warrant?
Well, because I wasn't sure it. I fell asleep. I went home and had a big bowl of chili.
That's not a reasonable excuse. Lucky for you, your attorney argued very zealously on your behalf, and I didn't issue a warrant, but you are coming back on Thursday at 10. I have notice here. Thursday at 10. Ooh, I even said the wrong time. I wanted 10:45, but I have a notice of hearing. Okay, come get your notice of hearing.
In the end, missing court turned into much more than a simple scheduling mistake. The judge made it clear that failing to appear can quickly bring serious consequences, including a warrant and added financial pressure. One missed hearing can change the entire direction of a case.